in Georgia, there are two kinds of custody. There's legal custody and physical custody. Legal custody is about who has access to medical records, who gets to make decisions for a child, and who gets to be involved in the decision-making process in general. Most parents do have joint legal custody, meaning that they both get to be participants in the decision-making process for their children. The courts require us to determine how a final decision is going to be made if the parents can't agree. The 4 areas that we have to spell out how a final decision is going to be made is education, religion, extracurricular activities, and medical decisions. There are a variety of ways how you can determine how a final decision would be made. In most parenting plans, the parent who is the primary custodian or who will have the child the most time on a physical basis will be the final decision maker if the parties can't agree. In other cases, parties might agree that either one can take a child to the religious institution of their choice on their weekend. They might determine that all medical decisions, they will just defer to what the pediatrician says, and that's how they make the final decision about medical. Or they might say that if they can't agree on something, that they're going to have a third-party parent coordinator help them mediate a decision. So it kind of depends on how well the parties get along already, or how easy or involved they want the process to be. The other kind of custody is physical custody. Physical custody is literally where is the child going to physically be on a daily basis. And the court requires us to spell out where a child's going to be during the academic year, during the school week. The court requires us to spell out where a child's going to be during vacation periods, like winter vacation, spring break. They also require us to determine where the child's going to be during the summer. That means the parenting plan that you have during the school year might look very different from what your parenting plan looks like during the summer. What the courts consider a standard plan is what we think of as the every other weekend plan for the parent who has secondary or is not the primary custodian. That is becoming less and less standard, and we typically see either parents extending those weekends so they're not just 2 or 3 nights. We see parents doing split parenting time where they might have every other week or every 3 days. There's a wide variety of ways that you can do a parenting plan. For summers, we see the standard plan is traditionally about 2 weeks in the summer for the non-custodial parent, but we see a wide variety of summer parenting plans that include alternating weeks, alternating months, or having one period of time for the non-custodial parent, and then the remainder of the summer for the primary custodial parent. In determining what the parenting plan and custody arrangement is going to be, the court looks at the best interests of the child standard. And there are a variety of factors that the court will consider, including the mental health of the child and the parties, where the child has lived the longest, both parents' work schedule and their capability for caring for a child, and the safety and well-being of the residents and the people that are living in the residence with the child. If the parties can go to mediation or otherwise agree between themselves what a parenting plan or custody agreement should be, they can write it up in a parenting plan agreement, submit it to the court, and the court will usually sign off on it as long as it has all of the required elements. If the parties cannot agree on a parenting plan, then the court will agree on one for you. The problem with that is that the court doesn't always take into consideration the unique needs of your family, your work schedule, the child's activities, and you can end up with a parenting plan that is wildly different than what you actually want or need. And so we do encourage people to try to work out a parenting plan either together or have your attorneys negotiate or go to a mediation to try to work out something that will actually work for your life.